The Treaties of the European Union are a set of international treaties between the European Union member states which sets out the EU's constitutional basis. They establish the various EU institutions together with their remit, procedures and objectives. The EU can only act within the competences granted to it through these treaties. An amendment to the treaties requires the agreement and ratification of every single signatory. Two core functional treaties, the Treaty on European Union and the Treaty on the Functioning of the European Union, lay out how the EU operates, and there are a number of satellite treaties which are interconnected with them. The treaties have been repeatedly amended by other treaties over the 65 years since they were first signed. The consolidated version of the two core treaties is regularly published by the European Commission. Content: the two principal treaties on which the EU is based are the Treaty on European Union and the Treaty on the Functioning of the European Union. These main treaties have been altered by amending treaties at least once a decade since they each came into force, the latest being the Treaty of Lisbon, which came into force in 2009. Lisbon also made the Charter of Fundamental Rights legally binding, though that is not a treaty per se. The troubled ratification of Lisbon has meant there is little climate for further reform in the next few years beyond accession treaties, which merely allow a new state to join. Treaty on European Union. Following the preamble, the treaty text is divided into 6 parts. Title 1. Common Provisions. The first deals with common provisions. Article 1 establishes the European Union on the basis of the European Community and lays out the legal value of the treaties. The second article states that the EU is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law and respect for human rights, including the rights of persons belonging to minorities. The member states share a society in which pluralism, non-discrimination, tolerance, justice, solidarity and equality between women and men prevail. Article 3 then states the aims of the EU in 6 points. The first is simply to promote peace, European values and its citizens' well-being. The second relates to free movement with external border controls are in place. Point 3 deals with the internal market. Point 4 establishes the euro. Point 5 states the EU shall promote its values, contribute to eradicating poverty, observe human rights and respect the Charter of the United Nations. The final 6th point states that the EU shall pursue these objectives by appropriate means, according with its competences given in the treaties. Article 4 relates to member states' sovereignty and obligations. Article 5 sets out the principles of conferral, subsidiarity and proportionality with respect to the limits of its powers. Article 6 binds the EU to the Charter of Fundamental Rights of the European Union and the European Convention on Human Rights. Article 7 deals with the suspension of a member state and Article 8 deals with establishing close relations with neighboring states. Title 2. Provisions on Democratic Principles. Article 9 establishes the equality of national citizens and citizenship of the European Union. Article 10 declares that the EU is founded in representative democracy and that decisions must be taken as closely as possible to citizens. It makes reference to European political parties and how citizens are represented directly in the Parliament and by their governments in the Council and European Council, accountable to national parliaments. Article 11 establishes government transparency, declares that broad consultations must be made and introduces provision for a petition where at least 1 million citizens may petition the Commission to legislate on a matter. Article 12 gives national parliaments limited involvement in the legislative process. Title 3. Provisions on the institutions. Article 13 establishes the institutions in the following order and under the following names: the European Parliament, the European Council, the European Commission, the Court of Justice of the European Union, the European Central Bank and the Court of Auditors. It obliges cooperation between these and limits their competencies to the powers within the treaties. Article 14 deals with the workings of Parliament and its election. Article 15 with the European Council and its President. Article 16 with the Council and its configurations, and Article 17 with the Commission and its appointment. Article 18 establishes the High Representative of the Union for Foreign Affairs and Security Policy, and Article 19 establishes the Court of Justice. Title 4. Provisions on Enhanced Cooperations. Title 4 has only one article which allows a limited number of member states to cooperate within the EU if others are blocking integration in that field. Title 5. General provisions on the Union's external action and specific provisions on the common foreign and security policy. Chapter 1 of this title includes Articles 21 and 22. Article 21 deals with the principles that outline EU foreign policy, including compliance with the UN Charter, promoting global trade, humanitarian support and global governance. Article 22 gives the European Council, acting unanimously, control over defining the EU's foreign policy. Chapter 2 is further divided into sections. The first, Common Provisions, details the guidelines and functioning of the EU's foreign policy, including establishment of the European External Action Service and member states' responsibilities. Section 2, Articles 42 to 46, deal with military cooperation. Title 6, Final Provisions. Article 47 establishes a legal personality for the EU. Article 48 deals with the method of treaty amendment, specifically the ordinary and simplified revision procedures. Article 49 deals with applications to join the EU, and Article 50 with withdrawal. Article 51 deals with the protocols attached to the treaties, and Article 52 with the geographic application of the treaty. Article 53 states the treaty is in force for an unlimited period. Article 54 deals with ratification, and 55 with the different language versions of the treaties. Treaty on the Functioning of the European Union. The Treaty on the Functioning of the European Union goes into deeper detail on the role, policies and operation of the EU. It is split into 7 parts. Part 1. Principles in Principles. Article 1 establishes the basis of the treaty and its legal value. Articles 2 to 6 outline the competencies of the EU according to the level of powers accorded in each area. Articles 7 to 14 set out social principles. Articles 15 and 16 set out public access to documents and meetings, and Article 17 states that the EU shall respect the status of religious, philosophical and non-confessional organizations under national law. Part 2, Non-discrimination and Citizenship of the Union. The second part begins with Article 18, which outlaws, within the limitations of the treaties, discrimination on the basis of nationality. Article 19 states the EU will combat discrimination based on sex, racial or ethnic origin, religion or belief, disability, age or sexual orientation. Articles 20 to 24 establishes EU citizenship and accords rights to it, to free movement, consular protection from other states, vote and stand in local and European elections, right to petition Parliament and the European Ombudsman, and to contact and receive a reply from EU institutions in their own language. Article 25 requires the Commission to report on the implementation of these rights every 3 years. Part 3, Union Policies and Internal Actions. Part 3 on Policies and Actions is divided by area into the following titles: the internal market, the free movement of goods, including the customs union, agriculture and fisheries, free movement of people, services and capital, the area of freedom, justice and security, including police and justice cooperation, transport policy, competition, taxation and harmonization of regulations, economic and monetary policy, including articles on the euro, employment policy, the European Social Fund, education, vocational training, youth and sport policies, cultural policy, public health, consumer protection, trans-European networks, industrial policy, economic, social and territorial cohesion, research and development and space policy, environmental policy, energy policy, tourism, civil protection, and administrative cooperation. Part 4. Association of the overseas countries and territories. Part 4 deals with association of overseas territories. Article 198 sets the objective of association as promoting the economic and social development of those associated territories as listed in Annex II. The following articles elaborate on the form of association, such as customs duties. Part 5. External action by the Union. Part 5 deals with EU foreign policy. Article 205 states that external actions must be in accordance with the principles laid out in Chapter 1, Title 5 of the Treaty on European Union. Article 206 and 207 establish the common commercial policy of the EU. Articles 208 to 214 deal with cooperation on development and humanitarian aid for third countries. Article 215 deals with sanctions, while Articles 216 to 219 deal with procedures for establishing international treaties with third countries. Article 220 instructs the High Representative and Commission to engage in appropriate cooperation with other international organizations, and Article 221 establishes the EU delegations. Article 222, the Solidarity Clause, states that members shall come to the aid of a fellow member who is subject to a terrorist attack, natural disaster or man-made disaster. This includes the use of military force. Part 6. Institutional and financial provisions. Part 6 elaborates on the institutional provisions in the Treaty on European Union, as well as elaborating on the structures. Articles 288 to 299 outline the forms of legislative acts and procedures of the EU. Articles 300 to 309 establish the European Economic and Social Committee, the Committee of the Regions and the European Investment Bank. Articles 310 to 325 outline the EU budget. Finally, Articles 326 to 334 establishes provision for enhanced cooperation. Part 7. General and final provisions. Part 7 deals with final legal points, such as territorial and temporal application, the seat of institutions, immunities and the effect on treaties signed before 1958 or the date of accession. Protocols, annexes and declarations. There are 37 protocols, 2 annexes and 65 declarations that are attached to the treaties to elaborate details, often in connection with a single country, without being in the full legal text. Protocols. 1. On the role of national parliaments in the European Union. 2. On the application of the principles of subsidiarity and proportionality. 3. On the Statute of the Court of Justice of the European Union. 4. On the Statute of the European System of Central Banks and of the European Central Bank. 5. On the Statute of the European Investment Bank. 6. On the location of the seats of the institutions and of certain bodies, offices, agencies and departments of the European Union. 7. On the privileges and immunities of the European Union. 8. Relating to Article 6 of the Treaty on European Union on the accession of the Union to the European Convention on the Protection of Human Rights and Fundamental Freedoms. 9. On the decision of the Council relating to the implementation of Article 16 of the Treaty on European Union and Article 238 of the Treaty on the Functioning of the European Union between the 1st of November 2014 and the 31st of March 2017 on the one hand, and is from the 1st of April 2017 on the other. 10. On permanent structured cooperation established by Article 42 of the Treaty on European Union. 11. On Article 42 of the Treaty on European Union. 12. On the excessive deficit procedure. 13. On the convergence criteria. 14. On the Eurogroup. 15. On certain provisions relating to the United Kingdom of Great Britain and Northern Ireland. 16. On certain provisions relating to Denmark. 17. On Denmark. 18. On France. 19. On the Schengen Acquis integrated into the framework of the European Union. 20. On the application of certain aspects of Article 26 of the Treaty on the Functioning of the European Union to the United Kingdom and to Ireland. 21. On the position of the United Kingdom and Ireland in respect of the area of freedom, security and justice. 22. On the position of Denmark. 23. On external relations of the member states with regard to the crossing of external borders. 24. On asylum for nationals of member states of the European Union. 25. On the exercise of shared competence. 26. On services of general interest. 27. On the internal market and competition. 28. On economic, social and territorial cohesion. 29. On the system of public broadcasting in the member states. 30. On the application of the Charter of Fundamental Rights of the European Union to Poland and to the United Kingdom. 31. Concerning imports into the European Union of petroleum products refined in the Netherlands Antilles. 32. On the acquisition of property in Denmark. 33. Concerning Article 157 of the Treaty on the Functioning of the European Union. 34. On special arrangements for Greenland. 35. On Article 40.3.3 of the Constitution of Ireland. 36. On transitional provisions. 37. On the financial consequences of the expiry of the ECSC Treaty and on the Research Fund for Coal and Steel. Annexes. Annex I lists agricultural and marine produce covered by the Common Agricultural Policy and the Common Fisheries Policy. Annex II lists the overseas countries and territories associated with the EU. Declarations. There are 65 declarations attached to the EU treaties. As examples, these include the following. Declaration 1 affirms that the Charter, gaining legal force, reaffirms rights under the European Convention and does not allow the EU to act beyond its conferred competencies. Declaration 4 allocates an extra MEP to Italy. Declaration 7 outlines Council voting procedures to become active after 2014. Declaration 17 asserts the primacy of EU law. Declaration 27 reasserts that holding a legal personality does not entitle the EU to act beyond its competencies. Declaration 43 allows Mayotte to change to the status of outermost region, Euratom, as well as the two main treaties, their protocols and the Charter of Fundamental Rights. The treaty establishing a European Atomic Energy Community is still in force as a separate treaty. Title I outlines the tasks of Euratom. Title II contains the core of the treaty on how cooperation in the field is to take place. Title III outlines institutional provisions and has largely been subsumed by the European Union treaties. Title IV is on financial provisions and Title V on the general and Title VI is on final provisions. Amendment and ratification. The treaties can be changed in 4 different ways. The ordinary revision procedure is essentially the traditional method by which the treaties have been amended and involves holding a full, intergovernmental conference. The simplified revision procedure was established by the Treaty of Lisbon and only allows for changes which do not increase the power of the EU, while using the passerelle clause does involve amending the treaties. As such, it does allow for a change of legislative procedure in certain circumstances. The ordinary revision procedure for amending treaties requires proposals from an institution to be lodged with the European Council. The President of the European Council can then either call a European Convention to draft the changes or draft the proposals in the European Council itself if the change is minor. They then proceed with an intergovernmental conference which agrees the treaty, which is then signed by all the national leaders and ratified by each state. First in the drafting of the Charter of Fundamental Rights with the European Convention of 1999-2000. Second with the Convention on the Future of Europe which drafted the Constitutional Treaty. Previously, treaties had been drafted by civil servants. The simplified revision procedure, which applies only to Part 3 of the Treaty on the Functioning of the European Union and cannot increase the powers of the EU, sees changes simply agreed in the European Council by a decision before being ratified by each state. The amendment to Article 136 TFEU makes use of the simplified revision procedure due to the small scope of its change. Any reform to the legal basis of the EU must be ratified according to the procedures in each member state. All states are required to ratify it and lodge the instruments of ratification with the government of Italy before the treaty can come into force in any respect. In some states, such as Ireland, this is usually a referendum, as any change to that state's constitution requires one. In others, such as Germany, referendums are constitutionally banned and the ratification must take place in its national parliament. On some occasions, a state has failed to get a treaty passed by its public in a referendum. In the cases of Ireland and Denmark, a second referendum was held after a number of concessions were granted. However, in the case of France and the Netherlands, the treaty was abandoned in favor of a treaty that would not prompt a referendum. In the case of Norway, where the treaty was their accession treaty, the treaty was also abandoned. Treaties are also put before the European Parliament, and while its vote is not binding, it is important. Both the Belgian and Italian parliaments said they would veto the Nice Treaty if the European Parliament did not approve it. Minor amendments not requiring ratification. The treaties contain a passerelle clause which allows the European Council to unanimously agree to change the applicable voting procedure in the Council of Ministers to QMV and to change legislation adoption procedure from a special to the ordinary legislative procedure, provided that no national parliament objects. This procedure cannot be used for areas which have defense implications. The Fourth Amendment procedure is for changing status of some of the special member state territories. The status of the French, Dutch and Danish overseas territories can be changed more easily, by no longer requiring a full treaty revision. Instead, the European Council may, on the initiative of the member state concerned, change the status of an overseas country or territory to an outermost region or vice versa. This provision doesn't apply to special territories of the other member states. Legend for below table. Amending membership ratified treaties. Legend for below table.